Hey, good morning, everyone. In family law, I thought I'd put up hopefully a semi-brief review of Chapter 5 dealing with child custody. One of the most important chapters in the book. It's the course is family law, and many people really hone in on the question of child custody. And this is an issue that develops even outside of marriage. That's why we don't call it marriage law. We call it family law because now over 50% of all children are going to be born out of wedlock, not in a marital situation. And custody rights are still at stake, whether a child is born in wedlock or outside of wedlock. There's going to be different procedures if the child is born out of wedlock than in wedlock, but issues are going to obviously come up where custody rests and how it will be determined between a mom and a dad and potentially other people because sometimes moms and dads aren't always fit. We're going to probably deal with that in a later chapter much more when we do something called a care and protections. That's what I call it for Massachusetts, when parents are incapable of raising their children because they're either abusive or more likely they're neglectful and they just can't provide for the general welfare of children. But the chapter starts off and talks a little bit about the history of it. I don't know if I'm going to test you on the history too much about it because we want to know what the status of the law is today. But at one time, women didn't have any rights in the law vis-a-vis divorce or vis-a-vis uh, children. It was entirely up to the male to determine how that was going to happen upon divorce or dissolution of relationship. The male had the right to raise their children to the exclusion of the mother, even if they wanted to at one time in history. We know that there was a shift later on, and then there was actually a legal presumption in favor of mothers, and a lot of people still think that exists. That's not true. There's not a legal presumption. What's a presumption? That once certain facts are in existence, we automatically deem others to be true unless overcome by rebuttable evidence. So some people think, well, all things being equal, mom's going to get custody under the law. No, that might be the result in many cases, but it's not because of the law favoring the mother over the father. It's circumstances that do it. So where do we stand now? We stand between biological parents, mom and a dad, that or adoptive, doesn't have to be biological, but I'm talking about parents of the relationship. They're legal parents, mom, dad. It could be two dads, two moms under Massachusetts law, certainly because both could have adopted and they both could be male or female. You can only have two, though. You can only have two parents. Now, what's interesting here is what's going to happen. Where are we going to? Now, if the parties can agree, generally the court will allow an agreement to prevail. So, if mom and dad are having a breakup of the relationship, whether it's a marriage breakup or just a breakup of a relationship outside of a marriage form, and they have children together, they can mutually decide how they're going to do a custodial relationship. Now, this isn't about child support. This is not about financial. I'm just talking about where the physical presence of the child will be. Will it be shared? Will it be a predominantly a mom having primary, what we call primary custody, or it will be dad having a primary custody? Now, we can also have situations, we usually don't even use terms like that anymore because they're considered distasteful and it creates acrimony between the parties. We call it a shared custodial arrangement, but one will be probably a primary one with one parent, and one would be a more of a visitation schedule. We don't like to call that, we just call it a shared schedule. That's different because we don't want to offend the parent that doesn't have what we consider to be primary custody. That can be done by agreement, but the court still reviews it. Why? Because what if the parent that's getting primary custody is unfit and causing a danger to the child's welfare? And even if it's agreed upon, nothing with regard to child custody or child support is fixed in stone because circumstances change. Maybe mom has primary custody right now, but she becomes physically disabled from a stroke or something terrible like that happens. We're going to have to change the circumstances. And same with if dad had primary custody. Maybe dad is in the military and he's going to have to go overseas for a stint. He's not going to be able to be the primary caretaker. We need to do a change of custody. But as a general theme, if mom and dad can agree how the custodial situation will work, the court will usually endorse that, unless what? The kids are put at risk. Parents have a constitutional right to raise their children, and the court usually doesn't interfere with the parties if they can come to a joint agreement on how they're going to live and where and under what circumstances. Dog's whining at the door. I'll be right back. And what your book is mostly concentrating on is not the situation where the parties come to an agreement. It's about whether or not the court has to intercede because they can't come to an agreement. And this is the area of family law I probably have the most disdain for. I can't stand it. I hate it. I used to do a lot of divorce work. I try to avoid it because when you have kids, the divorce never ends. And if you just have a relationship where you've had kids and we think we've come to a resolution, even after a trial, the situations may change down the road. And like I said, when it comes to child custody, there's nothing really permanent in there because circumstances can change and the court can review that custodial arrangements. The book does a really nice job. I have the 6th edition in front of me. I also have the seventh. Do I have the 7th in front of me? The 8th. I got the 6th in front of me. I have the 7th available online as an instructor's resources, but it's the same standard. It's called the best interest standards. There is no presumption. Mom does not have a legal advantage, nor does dad. The only time mom does have a legal advantage is in a paternity action. There is a couple that gets together, they have a child together, they break up. Mom is the presumptive parent because of maternity, but dad it may have to prove he is the biological father of that child in order to seek rights. And that's going to put a delay in the proceedings. And during the period of pendency of that controversy, the presumptive mother is going to probably have physical custody of that child that the parties can't come to an agreement. That puts dad at a disadvantage. Why? Dad later, after months of hearings and stages to go through and establish the paternity, he is now in fact the father. There's been a bonding situation going on with mother. And if mother's doing a reasonably decent job of raising the kids, we don't want to disrupt children's stability. And so mom will probably prevail in keeping primary custody. Although it's not a legal presumption, it's sort of a factual situation that in paternity actions, basically a child custody battle outside the realm of marriage, the moms tend to have a bit of an advantage. But generally speaking, the book does a great job. It lists, well, it doesn't number them, it lists A through L on the factors that go into best interest. They're very much common sense. It's everything we can think of about child rearing comes into whether or not a child should be placed primarily with one parent over another. Things like the love, affection, and other emotional ties between the parent and the parties and the children or child. The capacity, disposition of the parties involved to give the child love, affection, guidance, to continue the education, raising the child in his or her religious creed and spiritual heritage, if you will. The capacity and disposition of the parties involved to provide child with food, clothing, medical care. The length of time the child has lived, and here's my point, the length of time the child has lived in a stable, satisfactory environment, and we want to maintain that in most circumstances. So say the couple's already split up and they're living apart for a year. If they've been staying with dad during that year and they're comfortable and they're safe and they're doing well, we're probably not going to disrupt this, even though mother's coming forward now saying, I want to have primary physical custody. But we don't like to disrupt things. And that's why I'm always leery in a case back when I did practice in this area. I get somebody coming along and say, well, we're going to do this temporary thing. It's only temporary. Let's not worry about it. But the kids are going to stay with mom or dad for a period of time. I'm very, very worried about that because temporary tends to become more likely permanent if it's successful. We don't want to disrupt kids' stability. We just don't. The permanence of a family union, existing or proposed custodial home or homes, where are they going to live? I have a friend of mine who one time, luckily I didn't represent him, another friend did, and he was a good dad. He's a great dad. His kids, as a matter of fact, he just went to his kid's bridal shower. The child is now having a child of her own. This is almost 20 years ago, and he wanted to fight for custody. And he's a good friend. He was living in a trailer on his parents' property, and the trailer is not hooked to plumbing, so you have to go into the grandparents' house to use the shower and the bathroom and things like that, unless an emergency. And it was a leaky old trailer. It had tarps on the top. That's no way to live if the child has the option of living with the mother in a nice, clean, warm apartment that has running water and a toilet and a shower and all those kinds of things. And so it's not always about being a good person. It's about the surrounding circumstances that are part of the situation. And it looks at everything. And the book lists as many things as they can think of, but cases are unique. And that's why it's difficult to say, well, in my sister's divorce or my friend's divorce or my brother's divorce, every case has a certain degree of uniqueness to it. And it's hard to say, well, that happened there, it must happen in my case too. We take cases as they come, and each one has a little bit of a different variance. There's everything from mental health to drug abuse to alcohol abuse, you name it. It's all part of the factors that go into it. The moral fitness of the parties involved. Now, careful on moral fitness. A lot of people want to bring up that, oh, geez, my ex-wife or my ex-girlfriend's out sleeping with all kinds of guys, or the dad is out there and he's got 6 different girlfriends. He's bringing different girlfriends home, unless it actually impacts the welfare of the children. People's promiscuity and or love life tends to be ignored by the court. Parties always want to raise it because they're bitter. It tends not to have very much impact at all. But we're talking about moral in terms of something that actually is going to put the child in sort of a immoral situation or a viewing of immorality in some way. Don't take it as just because somebody on their own private time away from the children and outside the children's purview that's going to have any impact. It's not. The mental and physical health of the parties involved. What do you mean physical health? Well, sometimes people are physically disabled and they can't, if the child's very small, they might not be able to prepare meals for them or change their diaper or things like that. And the same with mental health. Many people, I'd say a vast majority of people, suffer on some kind of spectrum of mental health. We're not talking about those kinds of sort of ups and downs. We're talking about where it's going to actually impact their ability to care for a child. And sometimes people bring in that information quite often, that somebody's unstable. And sometimes I think it's used inappropriate. Sometimes in the process of going to trial, we can actually have the parties be evaluated for mental and physical health if we think it's a real concern. I think it's a bit abused, basically trying to insult the other party because you say we want them to have a mental evaluation. It's not always done appropriately. But sometimes people are very unstable and they have severe mental health conditions that make them, I don't want to say vulnerable, but vulnerable is a good word too, but make them erratic in their ability to care for a child. And we don't want them to primarily live it. It doesn't mean they shouldn't have visitation. And people who have had mental health in the past doesn't mean they're not stable now through treatment and things like that. So it's where we are at now. We take a snapshot at this moment. Sometimes people, oh, my ex used to be, addicted to opioids. Well, how are they now? And that's the test we use. We took a snapshot now, but part of now is how recently have they become clean and stable and things like that. But if there's been a long pattern of sobriety when it comes to drugs or alcohol, and a long pattern of mental stability, it becomes a non-issue. And rightly so, I think most of us would agree. The home, school, and community of record for the children. If I hate to say it, if one parent's living in a better community with better schools, they have an advantage to get primary custody. And here's the one that I'm not so keen on: the reasonable preference of the child. The older the child gets, the more likely the court would give consideration. Children almost never come into court to testify. They do that through what we call guardian ad litem. They'll go out and interview people, and they'll interview the kids and say, where do you want to live? And why do we take it with a grain of salt? My parents were not divorced. They lived together. My father died a few years ago. My mother's still alive, but they fought all the time. I always was kind of hoping as a kid they got divorced because they hated each other. And my father was a great dad. And my mother's a great mom. They're just very different people. But I can always remember thinking, if I went back and they were asking me at the age of 7 or 8, who would you rather live with? I probably would have said my dad, because I used to hang out with my dad a lot and shoot guns and do those kind of corny, manly things that young people did back in that era. And I can remember my father drinking beers and getting down to, once he drank about 3/4 of it or 80%, and get a little warm on the bottom and you want a fresh one. Guess what he did with the old one? Yeah, I gave him to me and my brother and my sister. Well, not so much my sister, because she was a little older and she was doing her own thing. But my brother and I used to compete on swinging down the last of the beers as a young kid. Today, that would be considered abuse or neglect. But think about it. If you're asking a young kid, where do you want to stay? He goes, well, I want to stay with daddy. Lets me stay up. Say this is a 12-year-old kid. Lets me stay up all night long playing, Black Ops or Modern Warfare or whatever the current big game. What's my kid was addicted to it. I was actually making money on it. Fortnite. One parent's very permissive, so the kid's probably going to say, I want to live with that parent. Kids don't necessarily need permissive parents to be serving their best interest. They need a home with a structure and an organization and things like that. So I'm leery when the book in all the books I've always done that suggest that the kid's preference plays an important role. I'm not saying it doesn't play a factor. I just think the court takes it with a grain of salt, and good guardian ad litems that do these investigations are often attorneys or social workers. And when they do that investigation, they'll beat around the edge to figure out why the child wants to be with mom or dad. Mom disappears for 3 days. I love it. I have the house to myself. Those are the kinds of things that backfires. I think is a little bit of a problem when you show, mom disciplines me, dad doesn't. I think that's just showing the opposite reason why we want to have the kid in one home or another. The willingness and ability of each party to facilitate and encourage a close continuing relationship with the other parent. We want both parents to speak highly of the other parent, even if they don't internally believe it, because we don't want to create a division between the non-custodial, non-primary custodial parent and the one that has visitation. It's just important to create a healthy environment. It's difficult for people to assess that, but that's part of the factors. Domestic violence, that's huge. If one party's been violent, they're much less likely to be a good candidate to be the primary caretaker. That doesn't mean they're not. It's just a factor we look at. And any other, and here's the one I love is L, any other factor considered by the court to be relevant, because we don't always know the situations. Dad could be the greatest father in the world. People don't know Ward Cleaver anymore, but there used to be a show called Leave It to Beaver, and Dad was a great guy, or Father Knows Best. There's actually a TV show called that. But what if he's a long-range truck driver and he's just not home for 3 or 4 days at a pop? You can't have him at primary custody. So this is only if we're talking about a contest between mom and dad, who should have primary custody. Again, the parties are able to agree. If they, mom, you should have primary custody. I should see the kids an awful lot, and if we're getting along, we can even keep it wide open, meaning that, I can visit, I can call and say, can I pick up Junior tonight at 7:00? I want to go out and, well, now it's COVID, but hang out with them for a few hours. And if the parents are fine by that, we can have a very, very loose nature of the way visitation will work. And sometimes that does work, but usually that's for parents. And this is on the test question. Why do we want structured visitation and custodial arrangements sometimes? Is because it's rare that parties can get along very, very well to work out these sort of ad hoc, we'll do it as we go kind of situations. Because most of the time, the reason why the relationship's breaking up is there's a lot of acrimony between the parties, and it's just not going to work. But sometimes you do get a couple that can get along very, very well for the best interests of the children, and they can work with a flexible schedule. It's rare, very rare. Yeah, parent-child bonding, past caretaking, time availability, stability environment, preference of the child. I'm not so keen on that one. Domestic violence is very, very big. I do a lot of domestic violence cases. It's amazing how much domestic, we know it from Chapter 3 in the Domestic Violence Restraining Order statute, chapter, how significant that is. Race and culture. I don't think sexual orientation comes up that much. Religion might, a little bit. Parental health. There is no law dealing with a presumption over mom or dad, because the 14th Amendment of the United States Constitution requires equal protection and equal application of the law. But does one party have a benefit over another? I think culturally we often, especially with young children, view mom, it used to be called the tender years presumption. Young children, people believe, and it's not legal, but people believe it culturally and societally, that kids are probably best being home with mom when they're very young. That is not the law. In fact, that is unconstitutional. What is the law is something called the primary caretaker presumption. Think about it. If I'm the one, or if dad's the one spending most of the time with the kids, maybe he's a stay-at-home dad or just works part-time. He's the one that makes sure he goes to all the parent-teacher conferences, goes to all the, say to the vet, because my dog's right next to me here. It's not the vet, it's, to the pediatrician. And they spend the time with the kids during the day, and they pack their lunch, and they greet them after they come home at the end of the day for school. They are the primary caretaker, and that's a huge presumption. And I think the law still follows it to this day. And we know, through history and culturally, who has often been the primary caretaker, especially of younger kids? The mom. But it's just that it's just a presumption. Presumptions can be overcome. So you can say, yeah, mom and dad both work, but dad's home more often because he works out of a home office quite a bit. He is available, and don't think of that as a primary caretaker function to presume it's always the mom, because it's, especially today, modern society changing. Women are entering the workforce like never before in professional fields as well as every field, and we can't always assume that presumption should be in favor of the mom. It could be in favor of the dad. And sometimes we have what? Mom and dad doing both. And that's what's really a heartbreaking thing for me. I know I don't like to do divorce work when there's children involved because of that situation. I've had it happen before where I'm interviewing clients. I know I want custody of my kids. I love my kids. I want my kids to be with me most of the time. Mom's not a bad person, or vice versa. Dad's not a bad person, but they should have visitation and they should make their primary home with me. But then through the investigative process, you find out, geez, the other party's probably done about an equal amount of the parenting. They're good people too. And that's when we try to potentially work out a joint co-parenting situation. Equal, both parents become primary custodial parents. The problem with that is if they're not getting along, it's very difficult to work. So I might as well just segue right into when do we have joint physical custody equal or roughly equal? It's when the parents usually live in the same community because we got to get them into the same school system. And if one's like 50 miles away from the other, they're not going to be in the same school system. So you got to pick one as the primary caretaker there, I think, in that situation, simply because of the school situation. You know how hard it is? I know because I've gone through a divorce with my 4 kids. Now we have 7, but through another marriage. But my 4 kids, we tried to do the joint physical thing, and they have to have 2 primary sets of clothes. They can't always remember to pack their stuff. And we did live in the same community, the same school system. In fact, most up until last year, I moved my house, literally walking distance towards my ex-wife's house for the benefit of the kids to try to facilitate more time back and forth. But it's really difficult because things would happen. I get a phone call all the time, or my kid will be with me, and I say, "Oh, Dad, I left my chemistry book at Mom's house." And back then it was 7 miles apart. I thought 7 miles was a nightmare, but we were in the same town, the same community, and it was still very, very difficult to have shared joint physical custody because it was hard flipping back and forth from week to week. And eventually it did erode to a point where the kids ultimately made their primary home with me. And it was with a lot of acrimony and a lot of bitterness, and it's very difficult, but it's very hard to do joint physical custody. It just is. But there is a movement towards that in Massachusetts. There's a movement towards that in the law that if the parents are both available and they're both decent parents, we try to do the joint physical custody. The problem with it, though, oftentimes with one party is the child support obligations change quite a bit. So the one receiving child support, they're going to be, maybe it's mom, she's going to be the primary caretaker. If suddenly it's a joint physical custody, the child support guidelines don't apply the same way. And oftentimes people believe the reason why they're fighting for joint physical custody is to save money. They don't want to pay an obligation to the other party. And the court will ferret that out through the process. And sometimes they'll give it a shot and see if it works. But man, I'll tell you, a lot of them don't work so great. So that's joint physical. Usually it's shared physical, one having primary household commitment, the other one having broad visitation. These are if they're both good parents. If they're bad parents, they probably get limited visitation. In fact, sometimes parents are abusive or neglectful. That doesn't mean we want to sever their parental rights necessarily, but they may have visitation with a third party to watch over because we're scared they're going to be that neglectful or maybe even be abusive. And at some point it gets so bad that we may have to terminate parental rights, and we'll get to that in a later chapter. Very rarely I shouldn't say rare. We have had a trend now to go to joint physical custody. Most circumstances it's going to be what? A shared physical custody with primary with one, mom or dad, and then the other party has what we call visitation or a lesser type of custodial time just to make it functional. What's interesting about that's the physical aspect. There's a legal aspect. In almost 95% of all cases, the parties are going to have shared legal custody. What does that mean? Both rights of inheritance, but also to make major decisions about the children's welfare. They need medical treatment. They need maybe changing of the school system, maybe which religion they're going to be brought up. That is considered a joint situation almost always. Very rarely when I hear people say, "Oh, I've got sole legal and sole physical custody of my children," I tend to doubt that until I look at the paperwork. And sometimes it's true because mom or dad is basically unfit. Usually it's joint legal and physical custody solely with mom or dad. That does happen a lot. So that way, if you want to remove the child from the state, you've got to get permission from the other spouse or get a court order. And we'll get to that in a minute. So those are the things. The book does a great job. You don't need to hear me blabbing about it when they do a great job. The visitation schedule, we don't want the visitation schedule to be crazy because it can be crazy. It can be very disruptive to a child if it's not organized in a very efficient fashion. And sometimes when people aren't getting along, when I used to do these things, I used to literally sit down and say, are we going to alternate everything from Halloween, Thanksgiving, and if they have a certain religious faith, we'll go through all those different holidays. Sometimes we'll alternate them. Sometimes one party doesn't care as much about a certain holiday, so we'll designate it to the other party to have that time. And we've got to bring it right down to time, 6 p.m. on this night till such and such on the next night. And a lot of people get very upset and say, oh, my ex-husband dropped off the kids an hour late. I want to file a contempt. Only over a long period of, you got to have some flexibility in these things, but it can be very, very dramatic. And people get very, very frustrated over chronic, what I consider to be minor violations of the rules on visitation. And be careful here. A lot of people want to terminate or not pay child support. So say I'm the payer of child support and I get to see my kids every other weekend. And I go to pick them up and mom says, oh, I forgot I'm away at the Cape. I took the kids to the Cape. I'm sorry, I'm not going to be able to have visitation this weekend. Can I basically pay less child support because I've been denied my physical? No. Child support and visitation are mutually exclusive. And the same is true of this other one. I pay my ex-husband a certain amount of money. He didn't pick up the kids this weekend. I don't want to pay him anymore. He's not participating in the kid's life. Or I think I should get more child support because he's not spending time with Junior. Mutually exclusive. People bring it up all the time, but they're exclusive. We'll get to that when we get to the child support chapter. But this chapter is very, very good. It's very, very in-depth. We do talk about situations about other people having visitation rights besides the biological parents. Step parents don't have any legal right. There's a movement to say, well, if they've been the equitable parent for 10 years and all of a sudden there's a divorce, can't they have some visitation with the minor children that aren't theirs legally? Generally, no. The court has etched out a few examples where there's such a strong bond between a step parent and a stepchild that it might serve the child. Remember, the standard's best interest, that we might let a step parent have some limited type of visitation with their stepchildren. And it's not really the trend in Massachusetts. If you're a step parent, you're out. They're not your kid. What about other people outside that? Yeah, there's been some cases in Massachusetts where aunts have been able to get some visitation. There's no statute for that specifically, but there is a statute specifically for grandparent visitation. Still has to be what? In the best interest of the children. What if the grandparents have never seen the children? Spent almost no time with them. Don't know them at all. And the kids are like 12 or 13. Like, I don't want to go visit these people. I don't know who the heck they are. The court's unlikely to order the children to see the children if there hasn't been a bond already with the grandparents. But grandparents can sue. There is standing and a right to do it. Most other people don't even have a standing. Friends, they're breaking up. One of my friends was very close. Maybe he's the godfather, which is a religious thing. It's not a legal standard being a godfather. They say, I spent a lot of time with little Jimmy Jr. I want to spend some time with him. And mom, who has primary custody, is not letting me have any access to the kid. I'm going to file. They'll be dismissed. They just don't have standing as a godparent. There has been some with it. Aunts and uncles have had some standing arguments sustained by the court allowing some visitation. But the only case I know is where the aunt raised the kids for a period of time in a very, very strong bond, and it was clearly in the best interest of the kids to allow it. We're really mostly talking about between biological parents or adoptive parents of children. Adoptive parents are just as strong as biological parents in the eyes of the law. Relocation disputes happens all the time. Get a couple, they break up. They say, Mom, you're going to have primary custody. Let's just use a classic case. The kids are 4 and 6. Mom's been the primary caretaker. Dad's still a great guy. They both live in Gardner. Okay, everything's going well. Visits are going well. The financial support's being distributed appropriately. And all of a sudden, Mom has this great opportunity with her new husband to move down to Maryland. Is the court going to allow that? Well, I would think the dad's going to object to it, right? Because he's having time with his kids. He's seeing them a couple days during a week, every 3 weekends a month. He's a very active dad. It's going to crush him. And what if mom even says, yeah, but when I move down to Maryland, I'll pay, a predominant cost to have them travel up here. Well, they're not going to travel up here every other weekend, are they? It's going to put a burden on them physically to do so. So it's going to curtail and hurt the bond between mom and dad. Between dad and the kids now. So the father would probably object, and mother cannot remove the kids without the father's consent. And usually you enter the consent into court, or mom's going to have to go to court, petition it. It's a mixed history here, meaning that I've had judges allow moms to move if they can show a real best interest that's going to flow down to the kids. Mom maybe had a real crappy job before. They had a very, really lousy apartment and they weren't doing well financially. And now when they move to Maryland, they're going to have a huge support network because maybe that's where her family was originally from. And this job she's getting is fantastic. And the school system the kids are going to be entered to are superior to where they were up in the Gardner area. All of those arguments will be placed before the court. But what's the court going to look at? But you're basically denying dad the ability to have a custodial arrangement with his kids. You got to really, really, some judges will just say, no, I'm not allowing it. Make a better life for yourself here. I'm not allowing it because it's Maryland, say it's Florida, say it's California. It's really going to make dad, you know, a memory. I know it sounds terrible, but family law is very emotional. And it goes both ways. It goes back and forth. The best thing I always try to, if I try to negotiate, what if dad wasn't spending a lot of time with the kids? Well, then it's easy. Then okay, not breaking a bond. That's very healthy. It's only sporadic already. Virtual visitation, yeah, I do Zooms. We used to do it. My kids, I remember FaceTime, I think it's called. I'm not big on that stuff, but I remember my kids would be over at my ex's house, and we're only 5 miles away, and they spent most of the time away. But they would always, we'd always do the FaceTime thing at night, and we got along well enough that she wouldn't interfere that, nor would I interfere if she tried to do it with the kids as well. Very, very difficult. Grandparents, already said there's rights there. Step parents, again, no legal right whatsoever, even after death. And that's one of the things I always put in people's wills, that like right now I have 3 step kids, although 2 of them are older, but one's still a minor. If my ex-spouse or my current spouse were to die, her ex-husband, the biological father of the child, who does have an active role in her daughter life, just come and pick her up. I don't have any say. Well, I want to visit her from time. He can give me consent, but I can't get it through a court, or step parents have no legal rights. But my current wife could put in her will that I'd be allowed to have guardianship of that child. Doesn't trump what the law allows. Biological parents have a right, constitutional right to raise their children. You can't trump it or subvert it by a guardianship request in a will. And again, a paternity action. Mom and dad are fighting, they break up. Mom's going to have the advantage. She's the presumptive parent because of maternity. Father, if she's going to fight it, is going to have to go through a paternity action. That's delaying it. What do we know? If there's a stable environment and practice already in hand, we don't like to disrupt it. And that's when we talk about temporary orders later, when we talk about court actions. Temporary orders that are working tend to become permanent orders. So don't be so keen on just accepting that as an appropriate thing. Great chapter. Read it slowly. Please ask questions if you can, and be well.